as the opening remarks went a little long. So with your kind permission, I would like to get started with this extremely distinguished panel. I'm Vicki Jackson. I'm on the faculty here, and it's been my great pleasure to teach many, many LLMs and supervise S.J.Ds, and it's been wonderful to see so many of my former students in the room and some current students as well. I am honored to be here with our four guests, and in light of time and the fact that you all should have this wonderful booklet, I'm going to introduce the panel only very briefly and in alphabetical order. Their full titles and illustrious careers are in your booklet. But we have the Right Honorable Lady Arden, LL.M. 70 and formerly of the UK Supreme Court. Welcome. We have Justice Gutiérrez, LL.M. 98 of the Supreme Court of Mexico since 2012. We have Judge Pangalangan, LL.M. 86, S.J.D. 90 of the International Criminal Court until 2021. And we have Judge Rhee, LL.M. 00, who is a judge of the International Tribunal for the Law of the Sea. Join me in welcoming them, please. Our hope is to have a discussion of some questions for an hour. We hope we'll have a few minutes for your questions. Although I know from many emails that many of you have questions already, if we get to them, I would ask that your questions focus on what the judges and justices have discussed, and if possible, things of interest to more than one of them. I will keep time, and I've discussed this with my colleagues, and the first question is actually two questions, and I'll ask Lady Arden to start. First is whether there's a memory, good, bad, or just interesting from their time as an LL.M. student that has been influential in their thinking. And second, if time allows, to say a little bit about how you came to be a judge on the court you were on. Lady Arden, you're up first.
Thank you very much, and welcome to everybody. And could I just start by saying thank you to the law school for having me in the first place. It was a fantastic year and program, and I would also say thank you very much to the Kennedy Trust in London, which was set up following the assassination of President Kennedy to send scholars to Harvard. And it has sent 77 scholars to the law school, and so thank you for admitting every one of us. It's much appreciated. Now, memories. Well, I went to a class yesterday and I wanted to point out one big change. I remember The Cold Calling. I'd read 1L by Scott Torrow, where people were reduced to tears by the questions and made foolish attempts to answer them, getting deeper and deeper into a mess. It wasn't like that at all yesterday. Almost professors had to ask if they could ask a question. And I witnessed the funniest thing that I thought I had seen in a long while, which is one student who said, "Thank you, Professor. You should not turn to me to answer your question when I haven't been listening." And the professor said, "Well, I'm learning something too." Anyway, so that was a big change. I thoroughly enjoyed the experience yesterday and class. Now, look, what it brought back to me was that wonderful memory. I came from a monoculture because having been at an excellent English university, I'd only studied English law. We don't even learn the law of Scotland or the law of Northern Ireland, let alone the law of Wales. So there I was, coming from a monoculture into a situation where if I was asked a question, I could pick any one of 50 jurisdictions to provide an answer. And it was like, if I can put it this way, looking in a kaleidoscope. Every time I looked into the law here, I could see all little pieces changing and the fact of a variety of laws. So that's my memory. I'm going to be very brief on professional pathway. Pathway sounds like I had an overall plan. I didn't. I came to Harvard because I love the law. I didn't have any career move in mind. I went back to practice at the bar, and for women that was a pretty unusual thing in 1970. And so I thought that's probably where I'd begin and end. Fortunately, and contrary to my expectation, I was asked to be a judge and then made my way up the ladder to the Supreme Court, which was a great privilege. But so far as a career path is concerned, I was a bit like Topsy. I just grew there.
Thank you very much. Justice Gutiérrez, the same two questions. A memory from your time at HLS, if you want to share, and how did you get to be on the Supreme Court of Mexico?
Well, thank you, Vicki, and I want to thank the Harvard Law School as well for the invitation. It's truly a privilege to be back at Harvard. I think no two people experience their LLM the same way. I grew up in the States. I went back to Mexico. So coming back and studying an LLM here was different for me. I wasn't looking for the experience of living in another country. I had already lived here for several years. I have only one memory of Harvard and the LLM program, and that's an immense amount of study. It was horrible. I had the LLM, and I was also in the international tax program at the time. So I read more about tax than I would care to forget. And I do not kid you, I visited Boston twice when I was here. And I remember I used to enjoy the weekends because that was the time when the classes would not interfere with my studying. But I had a severe burnout, which I didn't realize. It took me 10 years to come back to Cambridge. I had sort of like a surmenage every time I thought about. But I do have to say that everything that happened after, I can directly attribute to my time here and the amount of things I learned at Harvard. It's an amazing institution. Getting to the court, absolutely unexpected. I was at the time Commissioner of Customs and the IRS, and I was being named, I was possible named for Attorney General of Mexico. I lost out. I had already agreed verbally with a firm in Washington, D.C. to come back and head the Latin American practice. And the way justices are named in Mexico, the president sends 3 names to the Senate, and the Senate chooses. If they reject those 3 names, they send another 3 names to the Senate. And I remember I was at home watching the news with Tanya, my wife, and we heard that the 3 names had been rejected by the Senate. And she turns around and she says, "They're going to call you." I just laughed. I think I must have lectured her for about 2 hours on the type of person that gets to the court. I was just turned 43. Next day, I got the call. And then I was sent to the Senate and the Senate process. So no, I had no idea, never imagined I would get a call to be on the Supreme Court of Mexico.
Thanks very much. How about Judge Pangalangan? 2 questions. Memory from your LLM time and S.J.D. And how did you get to be on the court?
Thank you, Vicki. And I join my colleagues in thanking the law school for inviting us here. I recall that I had a carrel in the library. I don't know if you still have that. And leading to my carrel was a whole bookshelf of books on international criminal law. And each time I passed by that shelf, there were 2 thoughts in my head. The first thing was, it's never going to happen. Not in my lifetime. They won't create an international criminal court. The Cold War was raging at that time. It was impossible. The second thought was, well, one of these days, I'm going to read those books. Well, the court did happen, so I was wrong. I became a judge on the ICC. And the second was I never got to read those books until I was almost dean of the law school, actually. because the year before that was the drafting of the Rome Statute, and I took part, and of course, I read those books. I think a key element in my being nominated by my government as judge of the ICC is that precisely because no one else was interested in the field, I was one of the few who was teaching the stuff about Nuremberg and Adolf Eichmann and the other cases. And I owe that to my training at the Harvard Law School. That is, you see, people focus on the law that, how should I say this? You know, to use the felicitous term of Oliver Wendell Holmes, the felt necessities of our times. And sometimes there are needs which are not felt at the moment, and it takes scholars to look into them. And I think that was one advantage that I had in vying for the nomination for the court. Thank you.
Thank you so much. And Judge Rhee, could you talk to us about a memory from your LL.M. time and how you came to be on the tribunal?
Thank you, Vicki. And I'd like to also join the previous speakers in expressing my sincere thanks to the Harvard Law School, especially Professor Alfredo, for inviting me to be part of this prestigious panel. Yeah, there are many fond memories, but yeah, my memories are related to the international law courses. The international law that I studied in Korea was something given, something sacrosanct, set in stone, like the Ten Commandments or something like that. But the international law at Harvard Law School was quite different. It was something malleable and in the making and constantly evolving. And I took courses from Professor Alford, Professor Weiler, as well as Professor David Kennedy. And they taught international law with some different tones. And I can say that I learned 3 different types of international law. But when it comes to the degree of malleability, I believe that Professor David Kennedy's class was most extreme, actually, somewhat provocative in a way. And we were given the leading assignments about literary piece, essay on artwork, about Eiffel Tower, about Arab women wearing a veil or something like that. And I was wondering how to relate all these to the classical international law that I was familiar with. And this kind of approach was quite new, and I really had a hard time, to follow the class, and the lingering questions were never fully answered during the class, and the discussion among the students was also very confusing. So I'm not sure whether I understood about half of the class. But anyway, this kind of interdisciplinary and critical approach towards law was quite helpful in the performance of my duty as the legal advisor of the Korean Foreign Ministry. Having to put national interest before almost anything else is quite a daunting and challenging work as a lawyer. But thanks to this liberal and kind of critical approach that I learned in Harvard, I was able to grow viable yet reasonable ways for dealing with the issues, not losing sight of or deference for the rule-based international order. And this is also true of my work as a judge at the International Tribunal for the Law of the Sea, because our tribunal is a new tribunal and there are always constant demand for the development and evolution of jurisprudence. And without this critical and liberal approach, I cannot perform my duty to the extent that is satisfactory. Speaking of a judge, it looks like that nobody kind of had in mind to be a judge. And it was the case for me too, ever since I joined the foreign ministry, becoming a judge was not a thing that I ever thought of. But serving as a legal advisor, because the ministry wanted to make most of my legal study and experience, I was never detached from the legal affairs, even though I enjoyed my life as a diplomat much more than a legal advisor. And there was a turning point when I was serving as the legal advisor. Okay.
Soon, finish your
Okay,
sentence,
yeah.
please.
So at that time, the incumbent Korean judge at the International Tribunal for the Law of the Sea the term was coming to a close, and the Korean government decided to nominate a new person to replace him. And unlike in the past, they decided to nominate me, valuing my legal expertise and the experience, and also especially pinpointing my study at Harvard. And they nominated me as the candidate, and I was able to be elected at the meeting of state parties to the convention. Thank you.
Thank you very much. So, to all of them. So I think I'm going to ask you to actually hold your applause for the panel till the end, because we have a number of questions we want to talk about on the panel, and I will try to remember to give panelists an opportunity to comment on other panelists, but if I'm not remembering, gesture, and I will do it. But the next question that I'm going to put to the panelists is to ask them to discuss an issue that was significant or has been significant during their service on the court on which they served, that they've talked to you about. So we're going to turn now to that question about what significant issue, and we will start again with Lady Arden.
Thank you very much. I'm going to give you a brief summary of a case that we had brought against the Prime Minister. It's called Miller and the Prime Minister, who was at the time was Boris Johnson. And it concerned the prorogation of Parliament. Prorogation power is a power under the royal prerogative which the monarch has, then the late Queen, to bring to an end a parliamentary session. And this is done before another session starts. It's not a case of an election, but simply to allow a pause so that a new programme can be formulated and put to Parliament. Now, generally, this takes about 3 or 4 days. But what happened was, at a late stage in the Brexit negotiations, at a very delicate time of negotiations with the European Union, Boris Johnson advised the Queen that she should prorogue Parliament, and the period involved was 5 weeks, and it would be a critical time in the negotiations. So it was ostensibly to allow for the new programme to be formulated. This was immediately challenged, and the government, however, responded by saying this is something done under the royal prerogative, and it's an act of the monarch to dissolve Parliament, and that issue is not justiciable. But on that basis, the courts could not intervene, and indeed in the lower courts that was the result. In the Supreme Court, we said that the question was in reality a question about the extent of the royal prerogative. When could the monarch dissolve Parliament? And we said that the monarch could only do so where it did not frustrate and prevent Parliament from carrying out its primary role. So we wouldn't intervene if there was a prorogation which was ostensibly for a genuine political reason. But if it went beyond those boundaries, the courts would be able to say that the prorogation power had been improperly exercised, or rather that the advice to the monarch had been ill-founded and wrong in law, and so the court went on to say the advice given was wrong and the exercise of the prorogation by the power by the monarch was invalid, and so that when the monarch's representatives arrived in Parliament, took off their tricorn hats and said Parliament is dissolved, it was as if they were carrying a blank piece of paper. So Parliament was able to resume again, and the prorogation was set aside. We were not concerned, therefore, with an argument that we were dealing with proceedings in Parliament, because what we were dealing with was the advice to the monarch. So that was an exciting case. It was very controversial at the time because it coincided with the Brexit negotiations. Thank you for the opportunity.
So I just want to interject. This was an amazing case in the world. In the United States, presidential lawyers will often argue that the president is allowed to do something based on the history of royal prerogatives, notwithstanding that I thought we broke up a few hundred years ago. But so the idea that the British Supreme Court could adjudicate this claim was really quite remarkable. And I'd like to ask, maybe I'll ask Lady Arden to put it in the setting of the statutory change that occurred only in 2009, if I remember, about the status of your court, if you want to just take a moment to do that.
Yes, just quickly, our highest appellate court from the 19th century to 2009 was the Appellate Committee of the House of Lords. But this was a committee of Parliament. It was very difficult to go and watch the proceedings, and it sort of offended the separation of powers. And so eventually, in 2005, Parliament decided there should be a self-standing Supreme Court. But it inherits all the case law of the House of Lords. So it's as if nothing had happened. It's a seamless transition.
So there could be very little question about the practical independence of the UK Supreme Court in light of its decision in this case. Thank you very much. Let me turn now to Justice Gutiérrez to talk about a significant issue in his court.
Thank you. Well, in my experience, I think the most important cases are the ones I will never forget. The ones that touch lives and have a significant impact on society. We have many cases where we discuss the encroachment of the legislative to the executive, or the executive to the legislative, or state, federal issues. But I think the cases that touch upon and have a transformative effect on society are the ones I'm going to take with me when I leave the bench. It's a very special feeling as a judge when you're drafting the legal opinion and you know that opinion is going to have an impact, and you know that that opinion, once it gets read, is going to change society. And I want to touch upon very quickly 4 cases that I will never forget. The first one was in 2013. It was a simple divorce for cause. Back in those days, divorce had to be for cause. And it was an abandonment where the wife was accused of having abandoned her family, and so custody was adjudicated to the father. We granted cert on that case, and we reviewed the facts. And we realized that the reason why she had abandoned the family was because the father had thrown her out of the house. Now, that gave us the opportunity to establish legal principles on how to adjudicate with gender perspective. And we gave guidelines for adjudicating gender perspective. And after that case, all federal judges had the duty to review cases through a gender perspective lens. That was transformative for society. Another case was the Mariana Lima case. In a country where we have 9 deaths per day, violent deaths of women per day, and we have over 22,000 disappearances in the last 18 years of women, femicide is an important and tragic issue. Mariana Lima was a murder case where she had been deemed to have committed suicide. Carla Quintana, who's an LL.M. from 08, was my law clerk at the time, and she helped me tremendously with the draft. In fact, most of the draft is her work. But this case, we established the principle to apply gender perspective, not only for judges, but also for prosecutors. And this really helped because it established the principle that all violent deaths for women have to be investigated as femicides. This caused most of the states to change their criminal codes and establish femicide as a specific crime, and the protocols for investigating crimes with femicide. The third case, same-sex marriage. This was in 2015. This was months before Oberfeld. And this was a very interesting case. Article 149 of the Civil Code was challenged. It established that marriage was a contract between a man and a woman. The interesting part about this is that a group of men self-identifying as belonging to the LGBTQ+ community presented the challenge of the constitutionality of that article of the Civil Code. And they explicitly said they did not want to get married. So the issue of standing was very difficult. There is no state action. Obviously, this was thrown out at the district court level. We granted cert, and the issue of standing was revised. And we said, yes, they do have standing, because the law on itself, one thing a norm does is it establishes rights and duties. But another thing it does is it sends a message, especially in a democratic society, about the values of that democratic society. And the fact that that law is on the books stigmatizes and creates structural discrimination. So we granted standing, and we declared unconstitutional the law. This is the only time I can remember where people actually came out to the streets in protest of the decision by the Supreme Court. Mexico is a very Catholic, very conservative society, and this was not well taken by the society as a whole. This is probably the clearest example of a court taking a counter-majoritarian position in society and really transforming. The last case I want to mention is 2021, and it has to do with reproductive rights. We went exactly in the different direction as the US. In 2009, Mexico City decriminalized abortion. The case was brought to us by the Attorney General at the time, which the federal government had a conservative government at the time. They challenged the constitutionality. The court in 2011 said it's a state issue. What happened next? All state constitutions were amended to say life begins at conception. 2001, the Constitution of Sinaloa was challenged on that issue. I had the privilege of writing the opinion declaring unconstitutional the fact that a state constitution could establish that life begins at conception and affirming a woman's federal constitutional right to choose. Those are the four cases. I only had 4 minutes, so I just went through them very quickly. But those are the cases, I think, that are very important. The cases that transform society, the cases that touch lives, and the cases that allows a judge to really take a position on social issues and hopefully make your country a better place. Thank you.
Thanks very much. That was a generous 4 minutes by my count. May I just ask quickly about compliance? Have there been compliance problems with, say, the 2021 abortion decision, or has the court's judgment been pretty well accepted?
It was a unanimous decision.
That can really help.
And that really helped.
Okay.
It has now been extended to practically all state constitutions. The challenges came pretty quickly after that.
Okay. Thank you very much.
So, yes.
That's very interesting. Thanks so much. Let me next ask Judge Pangalangan to reflect on a significant issue in the work of his court while he was there.
Thank you so much, Vicki. Well, the issue I'll discuss is nothing as dramatic or as earth-shaking as those of my colleagues. It is a rather procedural issue, but I've got to tell you, we've got emotional debates within the ICC about these issues. We have a current ICC judge here, Gotcha Lord Kipanidze, judge. And Gotcha, please tell me if the debates still rage on these issues today. It is the clash between the civil law and the common law judges, between the inquisitorial and the adversarial systems. And the Philippines, being a former colony of Spain for 350 years, and of the United States, well, officially for about 50 years, I did not realize how good an American colony we were until I encountered this debate, because our system is entirely a common law when it comes to criminal procedure. I'll give you 3 examples. The first is that of all the 18 judges, the civil law judges are dominant. For the plea of guilt, the civil law guys say that, well, sure, the accused has pleaded guilty, but we still want to proceed to trial. Because his truth is just a subjective truth, we want the objective truth from independent witnesses. On demurrer to the evidence, if the prosecution rests his case And in the system that most of us know, if they fail to prove guilt beyond a reasonable doubt, they are unable to overcome the presumption of innocence, then the court can approve a demurrer to the evidence. The civil law guys say, no, 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 we want to proceed to trial. And by the way, they have very good examples from the Yugoslavia tribunal, where three guys were, guilty of the attack on the bridge, the historic bridge at Mostar. And the one guy who confessed basically got a heavier penalty compared to the guys who went to full trial. Eventually the court adopted the demur to the evidence, but they refused to call it by the common law title. They called it no case to answer. In fact, that debate has raged to the extent that that the fight is almost just about the legal terminology. And just the last example is the recharacterization of charges. For the civil law guys, they are more open to recharacterizing charges later in the trial to meet the evidence that is available to the court. And of course, for the common law judges, such tardy, a downgrading of the charges is seen as a violation of the rights of the accused. My closing point: for this comparative perspective, the other debate is why limit yourself to the civil law and the common law? There are so many other legal systems all over the world. Well, I've got to tell you guys, I took part in the drafting of the Rome Statute, and these former colonies never presented their own versions of their own cultures and their civilizations, because they were such good colonies that for their lawyers and for their legal professions, it was a matter of pride to show that they mastered the legal system of their colonizer. That was the mark of excellence, that if they were French, for a former French colony, then they can make the classiest arguments in French law. And for Filipino lawyers, the best arguments in American constitutional law. Thank you.
Thank you. Can I just follow up? You told us about the trial with the three co-defendants, and you said at least initially the one who confessed had gotten the heavier sentence. Did that change or as a result of hearing more evidence?
No change. In fact, that is the case record as it stands to this day. But I'm pleased to say that I presided over the first case on the plea of guilt. Well, of course, I had two colleagues. We were a trial chamber of three. My two colleagues were from civil law jurisdictions, and we found, some common ground toward the end.
All right. Thank you very much. And Judge Rhee, if you could talk to us about a significant issue from your court, that would be great.
Thank you, Vicki. Before talking about the cases, I just would like to familiarize you with the tribunal itself, because I don't think many of you are quite versed with Int'l, International Tribunal for the Law of the Sea. Actually, Law of the Sea is one of the most prominent and historically contested areas in international law. We know Hyoung from the Netherlands. He is considered the founding father of modern international law. And even his first book or kind of work was about the law of the sea, before the law on war and peace or something like that. And about 71% of the surface area of the globe is taken by seas and oceans. And lots of activities are going on in the seas and oceans. Navigation, trade, fishing, exploitation of natural resources, marine scientific research, military operation, you name it. So these activities are regulated by a certain legal regime, and that regime is UNCLOS, United Nations Convention on the Law of the Sea. And there are 170 states parties to this UNCLOS, this convention. And then what is Int'l? Int'l is the body, standing body, and also specialized body dealing with law of the sea affairs regarding the disputes concerning interpretation and application of the convention itself. So that's where the tribunal sits. And I'd like to share with you a case which was not a contentious case, but an advisory opinion case that was delivered last May. There was a request for an advisory opinion from an international organization called Commission of Small Island States on Climate Change and International Law. And the question was, what are the specific obligations of the state parties to the convention with regard to the greenhouse gas emissions in the context of climate change? And the court gave a unanimous advisory opinion. There are provisions on the protection and preservation of environment in the convention itself, but there is no specific reference to climate change, ocean acidification, or greenhouse gas emissions, etc. But the court, the tribunal, was able to say that greenhouse gas emissions belong to the pollution which is regulated by the convention, and that pollution has to be prevented, controlled, and reduced by the states parties. So, borrowing the terms from relevant international legal instruments as well as authoritative scientific works like IPCC reports, the tribunal was able to adapt to the new challenges. This is a good example of the tribunal. This body of law is evolving to address new challenges and also contributing to the overall development of international law in the light of advancing scientific knowledge and emerging global concerns. And we are yet to see how much impact this advisory opinion will have on potential contentious cases. And also, we do not know yet how much impact it will have on the ongoing climate change negotiations. And there are also two other cases, advisory opinion request in ICJ, before ICJ, and also Inter-American Court of Human Rights. We have yet to see that, and there are also more than 2,000 pending cases in national courts. So I hope the pioneering work of Int'l will help pave the way in dealing with climate change in right direction. Thank you.
Thank you. That's very interesting because I was wondering about the impact on other tribunals, on even things like oil and gas licensing proceedings. It could be a very, very substantial effect in the future.
Yes, it does not have a direct impact,
Right.
actually, and since this is an advisory opinion, it has no legally binding force, but also authoritative force. Yeah, we cannot deny that.
But an important new persuasive authority on an issue of vital concern to all of us. Well, this was really interesting. I'm looking at the time, and I think what I'm going to suggest for our next question is if the panelists could try to answer it in about 3 minutes or so, rather than the 4 we started out with, and I'll interpret 3 generously. But the next question is to ask you to describe any major challenges or concerns that are facing your court. I'm sure we have a very prominent example on the panel of major challenges, but we will continue to stay in alphabetical order. So I'll ask Lady Arden to talk first about the UK Supreme Court. Thank you.
I'll be very brief. I'm no longer a sitting member of the court, so I can only talk about my own tenure. And I'm not going to talk about jurisprudential challenges because the court is well up to it. But I'm going to talk about 2 things. One is method of appointment of justices, and the other is about communication across the public. So far as appointment is concerned, it is a principle in the UK that appointments as judges are independent of Parliament and the executive. So there is an independent commission, and there is no politician and no member of Parliament on that body. People are not chosen for their political allegiance, but solely on merit, and that's what statute requires. Secondly, on communication with the public, well, you've heard about how the Supreme Court had to segue from being in the House of Lords, the legislature, to being an independent court. It immediately realized that it had to tell the public that it was the Supreme Court. And so it took action by way of live streaming all its proceedings, so that you can switch on your television or your computer and watch what is going on in real time. And at the prorogation case that I described, there were 150,000 hits within the first few minutes. All the live streaming is kept, and you can go onto the website, and for any case that's been heard since 2009, you can click and find the live streaming of the hearing, plus the judgment and the press summary. Now, that press summary is important because the judges are communicating with the public by preparing a short summary which they give in open court on television or live streaming to tell the public in simple terms what the decision means. So in that way, and going out to schools and trying to bring home the message of the rule of law, the court is rising to the challenge of this media generation.
Thank you very much, both for interesting points and for being so timely. And I want to say we're sort of going from one end of a spectrum of judicial selection mechanisms to another end of the spectrum as we turn to Justice Gutiérrez for the challenges facing your court.
3 minutes, right?
I'm going to add a minute. I'm going to add a minute because Lady Arden was so concise.
Well, for me, I think that the challenge is constitutional and democratic backsliding. As some of you know, Mexico had for 70 years a single party rule. And then beginning in the 90s, democracy started to be taken seriously in Mexico. And one of the big amendments was a change in our court system. In 1994, we committed to having a truly constitutional court. And the first couple of years of this constitutional court were spent in adjudicating issues of federalism and separation of powers. What had traditionally been the area of backroom deals between the president and the governors, or Congress and the president, suddenly became issues to be discussed and to be adjudicated in court. So the court assumed the role as an arbitrator between state, federal, and separation of power issues. Then in 2011, there was a huge, tremendous reform in human rights in Mexico, a constitutional amendment. And the court not only assumed the role of arbitrator between powers and arbitrators between state and federal, but it assumed truly a counter-majoritarian role. This court adjudicated issues on rights of the accused. It adjudicated issues on women's rights, LGBTQ plus rights, marriage, adoption. It struck down from two different administrations laws that would militarize the country. It also became the guardian of the democratic model of the country, because laws that have to do with the electoral issues are adjudicated directly by the court. So we became the guardian. We struck down several laws that attempted to encroach upon the Autonomous Electoral Institute. And this all came to what appears to be a halt last month. The Congress, the new Congress, which was overwhelmingly won by a single party, just reformed the Constitution, and now all sitting federal, district court, and Supreme Court justices will have to be elected. This means an election of over 1,700 judges. It is the end of this era, this constitutional court era. Secondary laws are still to be enacted, so I do not want to give my opinion as to whether these will pass constitutional muster. We will see in the coming months. But this is a very dramatic change. At the very least, we will have an enormous period where the courts will not be predictable, because all justices, all district court judges, and all circuit court judges will have to be elected. Now, the requirements to be elected, and again, we still have the enabling legislation, are, and I kid you not, having a 3.0 grade point average, our Constitution says that now, and 5 letters of recommendation from your neighbors. If you have those, if you meet those requirements, you can be proposed to the Supreme Court, provided you win an election. Now, I really don't know what is going to happen, and I will not opine on the constitutionality of the reform. Thank you very much.
All right. Thank you. Well timed there. I can understand a sitting judge's reluctance to comment. I'm not so reluctant, and I want to say this is a major development, and one that I think most comparative constitutional scholars are extremely concerned about. Some of you may be aware, state court systems in the United States, actually a majority of them provide for the election of some judges, but they are nested in a federal system with federal courts that enforce a federal constitution. So that provides a degree of constraint. So it will be very interesting to see what happens next in Mexico. Now, let me turn to Judge Pangalangan for comments about the challenges, major challenges that your court had, that the court you were on has faced.
Thank you so much, Vicki. 2 things. First is about the social context of litigation. I took part, my court has lots of cases on child soldiers. And the first thing you have to prove there, that the prosecution has to prove, is the age of the child. So you can imagine, you ask any American child, when is your birthday? And that kid will answer with, excitement and expectation. Why else will you be asking for my birthday? Well, for my court, that is a challenge. Usually there are no birth records in the places where these crimes are committed, and usually there will be different birth dates on the school record, the baptismal record, and the refugee record, and the disparities in those dates will be used to harass the witness, saying, well, you are telling a lie to the refugee officer. And at that point, the witness breaks down. And the other way to harass the witness is to ask, these kids are usually abducted around age 10, 11. That is supposed to be the ideal age for boys to be recruited, to be abducted into to becoming child soldiers. The other way to harass them is to ask them about their level of literacy. And uniformly, if you ask them that, if they are asked that question, their eyes will cast down, because they were forced out of school at such a young age, and they were never really able to catch up. The second challenge to my court is this is a criminal court, so there is selectivity in the cases to be filed. And usually, of course, we all hope that the most guilty will be the ones tried. But it doesn't always happen that way. The cases will be filed where the evidence is available. It's almost like the Al Capone dilemma. A guy who must have machine gunned a lot of people and gets nailed for tax evasion. And the other problem with selectivity is state ratifications. The US has not ratified, for instance. But you see, it is not that simple. The last case that I handled in the court was Dominic Ongwen, an officer of the Lord's Resistance Army, which committed this crime of recruiting child soldiers. in the ICC, we don't ask how we got custody of the accused. I mean, it goes all the way back to Adolf Eichmann. It turns out, and this is not in the case record, I just read about it in the papers, he was actually captured by US troops. He surrendered he was brought into a US helicopter. They were told that a rebel commander had chosen to surrender because he was afraid that he was about to be killed by his other co-accused. And then voila, we had Dominic Ongwen under the custody of the court. So, it is, of course, the hope. We call it the campaign for universality, that more states would ratify the Rome Statute, and that the member states will actually carry out their responsibilities under the statute. Putin was about to visit South Africa. We have a warrant the court has a warrant of arrest against Putin, and despite all the braggadocio, Putin basically, in the end, chickened out of the appearing in the conference in South Africa. Well, we heard recently he was in Mongolia, and Mongolia had a treaty obligation to arrest him. Well, he dared go there, and Mongolia did not dare arrest him. Thank you.
Thank you very much. So big challenges for a court trying to do something really unprecedented before developments of the late 20th and now 21st century. Very important to the rule of law. Sorry, my phone. Judge Rhee, challenges for your tribunal.
The bell rang even before I talked, okay?
No, that was for me.
I'll be careful, yeah.
That was originally for me, I think.
Okay, it's $1 million question, and I believe each and every judge in my tribunal will have a different idea. So I'd like just to share my personal take on this issue. As I already mentioned, that our tribunal is a quite young tribunal, even though it deals with very old issues, centuries-old issues. It was established in 1996, and until now, for the past 27 years, has received 33 cases, and 2 cases are pending. During these years, it has made great contributions, and actually, I cannot go into details. It might be too technical, but prompt release of the vessels and the crew, on the posting of reasonable bonds, or environmental protection, the right of the flag state to make claims in respect of its vessels, maritime delimitation beyond 200 nautical miles of the continental shelf. So it sounds a little bit more technical. So it has been making great contributions, but I don't think the potential has yet to be tapped by state parties to a great extent. Int'l is relatively unknown and unfamiliar to the decision makers and those who are dealing with international legal affairs. Most of the law of the sea affairs have been dealt with before the establishment of Int'l by ICJ as well as by arbitration. So these are the kind of mechanism that many of them are familiar with, and they still have difficulty in understanding the role of Int'l, even though it has many benefits and merits compared to other mechanisms. Still, when there is a case, Int'l might not be the first and foremost forum for dispute settlement procedure that come into their mind. Of course, there are some indications that this might not be as true as it used to be. The cases are increasing, and also the subject matters of the cases are also diversifying. But still, we need to develop further how to make use of Int'l in a more effective way. Enhancing the understanding of the dispute settlement procedure in general, and also enhancing the understanding of the role, specific role that Int'l alone can play in these dispute settlement procedures is something very important, and capacity building in this regard is quite important. So Int'l, in collaboration with other governments as well as some institutions, are involved in these capacity building projects, and legal advisors from all over the world are invited to come to Hamburg, and then they get to know how the dispute settlement procedure works, in general, and also in particular at the setting of Int'l. So I just hope this kind of capacity building activities, programs will continue and further expand. Now I did it.
Perfect, thank you. You beat the timer. But, I was wondering whether the advisory opinion on climate change, which I'm sorry, I'm not very good at turning
that was
on.
close call.
It was for me. Whether the advisory opinion on the climate change issue, which I think is the first from a UN-related international tribunal, will raise the profile
Yes.
of your tribunal. I would think it would, yeah.
Definitely,
Yeah.
I do hope so.
All right, great. Well, thank you very much. So I think in light of the time, I'm going to ask members of the panel if any of you would like to comment on the comments of any others, or share any thoughts about things you think HLS's graduate program should be doing that it isn't. So I'm going to give you a chance to think about whether you want to say something. And then those of you who have questions, I will be turning to you momentarily. And I will do what I do in my classes, which I'll ask, who has questions, and I'll look around the room a little bit, because I've learned not to immediately call on the first hand up, because that has certain demographic effects. But anybody on the panel would want to comment. Lady Arden?
Could I just very quickly say how much I agreed with the remarks in particular of the Vice Dean about the purpose of the LL.M degree. I benefited enormously, and I can cite both intellectual reasons why I benefited, but also direct impact on my own career of things that I did thereafter. Just quickly, I studied under Professor Lon Fuller. He taught about the morality of law and about the function of soft law in society. I took that back. We hadn't then come to that age of financial regulation by soft law. But of course, I was able to deliver those thoughts at that time. And indeed, in a judgment in the Court of Appeal, I set out the fuller definition of the law, what the law had to achieve to be law, which didn't necessarily mean it had to be statutory, but it had to have certain qualities. In corporate law, I had a discussion with my professor about shareholder actions. It was time of Ralph Nader, and he couldn't understand why our law was incredibly conservative. So he said, you write your thesis at the end of the course on the difference between US shareholder actions and UK actions, which I did. I got, obviously finished it, I put it away, and then when I got to be a judge, I was asked to be chair of our law commission. And guess what? I was asked by government to formulate, the commission should formulate recommendations for the change of the law on shareholder actions. So out came the thesis, and we made recommendations, but in the way of things, of course, Parliament's much too busy to implement them. But about 5 years later, sitting on yet another company law reform committee, we had exactly the same point. And so I pulled out the thesis again and the Law Commission recommendations. They were approved again, and they became law in 2006. So I hope that we can be ambassadors for what we've learned in here in Harvard. I hope that the law school will continue to have a good representation from the UK, and that my colleagues will, who follow me will continue to participate and contribute in the way I hope it's already been done. And to the law school, I say, keep marching, please. It's really great.
Thank you so much. Anybody else on the panel wish to comment before we go to questions? Was that a yes, or you would like to comment, Justice Gutiérrez? Yeah.
Well,
Okay.
I think one of the benefits of the LL.M program is comparative law. I mean, you just are so much better at what you do, at your practice. if you know other law systems. It's very hard not to emphasize the importance. And courts read other courts, and they learn from other courts. And if you have a background a strong background, like the one you acquire here on comparative law, you understand a lot better the decisions that other courts are making. So I would say it's a tremendous asset. And the more we move away from our country's exceptionalism and we embrace global decisions and cases and laws from other countries, we will be much better as attorneys and as judges.
Thank you very much. I heard from Judge Pangalangan that he has an additional comment.
I will actually join Justice Gutiérrez and push it specifically to comparative legal education. I came from a very formalistic legal education in the Philippines, very practice-oriented. But I came in to law school as an activist. I was active in the protest activities against the dictatorship at that time. And I felt out of place in my law school in the Philippines. I love to look at law from the standpoint of history, of activism. And when I arrived at Harvard, suddenly I felt at home. I wasn't an aberration. I wasn't out of place. The transformative power of law was fully recognized in this campus, and it gave me confidence about the approaches to law that I eventually adopted as a law professor.
Thank you very much. Judge Rhee, did you want to get in? No. Okay. So let me, if I could thank the panel again, but let me see if there are any questions. Oh my gosh. Okie doke. Let me see. I think we have a judge from the ICC here, and please would you ask the first question? Thank you. And then next time, put your hands up again when we're done.
First of all, let me introduce myself to make it clear. I would be not asking questions, rather making comment, picking up on the point raised by former Judge Raul Pangalangan, my dear colleague. So I'm Gutiérrez Kipanidze, President of the Appeals Division currently at the ICC. And I can confirm, Raul, that the debate about no case for answer is raging at full swing. So, and you have all kind of, definitely that one of the popular arguments that's it's a transplant, it's an attempt to transplant from the case law culture. So we have the ongoing debate, but what is necessary to, and that's my biggest point about the value of education at Harvard. I think when I came at Harvard with the legacy of having, negotiated Rome Statute together with Raul Pangalangan, with the expectations, here we all understood that law, above all, it's the culture of legal thinking. So we shared that culture of legal thinking, and after Harvard, I was asked by one American journalist who was writing an article about graduates from the Ivy League universities in the US, and I replied when he asked, what does it mean, having been graduate from LL.M program? I replied that after Harvard, I feel that I'm neither American nor European, but at ease with both ways of thinking. That's what remains with us. That's the biggest value of having graduated from the Harvard Law School. And that's why, by the way, in this debate also, my proposal, perhaps it's not about civil law and case law divide, because I was at ease with this procedure in understanding, and I propose just to tune it into institution that we have specific in hybrid law system, which is confirmation of charges. It's just to do confirmation of charges at the trial stage. That was it. Thank you.
Thank you very much for your comment. Oh my gosh, there are so many hands. In the back, I see, yes, the woman sitting at the table towards the back. Your hand, you, blonde hair, pulled back, black shirt. I'll try to get to you, I'll try.
Thank you for an excellent panel, and Judge Pangalangan, it is fantastic to see you again. My name is Jennifer Tribunal. My question is actually to the judge, but the other participants on the panel are also welcome to reflect on their experiences when it comes to the perception of the court before they joined and what they think of it afterwards. But Judge Pangalangan, you were involved in the drafting of the Rome Statute, which ultimately formed the court. But now, having served as a judge, having seen how the proverbial sausage is made, what do you think of the court as a project of the international community?
Well, thank you. Jennifer worked in my chamber as an intern. Thank you so much for the question. Quickly, it is an experiment that we should sustain. There are many criticisms of the court today. I won't go into detail. But the question is, if you reject the court, what do you replace it with? So it is important normatively to maintain the presence of an international criminal court. Otherwise, the fight against impunity will be defeated. And what we're trying to avoid is a world where those who commit war crimes and crimes against humanity mingle amongst us as if they don't owe us any apology, as if they don't owe us any reparations. So I think we do need the court.
Thank you very much. So we're running very short on time. I'm told we have about 3.5 minutes left. I'll call on this gentleman and that gentleman at the middle table there because I can see you. Could you each try and get your questions out in 30 seconds, and we'll take both questions and then the panel will respond. Okay? So 30 seconds each, and then whoever on the panel.
Thank you very much. Leo Rasnovich, I'm an English barrister, work in the Caribbean. You guys have been debating about the court being used as a tool to progress law. My question is the reverse. What happened when the court is used as a tool to oppress? And the example, and perhaps this is to Lady Arden, is the British judiciary has been oppressing the Caribbean people for centuries, even today. Lady Arden sat in a panel of judges that actually saw a same-sex marriage case from Bermuda. Every single judge in Bermuda found that the Constitution of Bermuda requires same-sex marriage. Lady Arden, with 4 colleagues, to reverse that, all the judges of Bermuda. Why, Lady Arden, do you think the law in this case needed to be used to repress the people of Bermuda? Thank you.
Thank you for coming in on under time. And last question to you, to that person right there. 30 seconds.
Good morning. My name is Anas Adam. I'm the LL.M class of 25. I wanted to ask if you could each comment on the nexus between law and social change. Although the judiciary is supposed to be an independent branch, that nexus, whether it be in the international sphere with cases like Miller 2, the International Law of the Sea, or in Mexico. Thank you.
Great question, under the time limit. And why don't I ask Lady Arden to start, since one of the questions was directed to her. And then the other question about law and society is for anybody.
I chose the prorogation case because it illustrates an important proposition, and that is that be you ever so high, the law is above you. And that was true for Boris Johnson, our Prime Minister, even the Prime Minister of the United Kingdom. Now, in the case of the Privy Council, and the members of the justices of the Supreme Court sit about 40% of their time as judges of the Judicial Committee of the Privy Council, which is an international court, having jurisdiction over about 35 countries as the final court. In the case that has been mentioned, what the court was asked to do was to interpret a provision in the Bermudian statute, which said that notwithstanding any decision of any court which it named, the particular case was called Goodwin, and notwithstanding anything in their Human Rights Act, marriage, now it meant a marriage between a man and a woman. And the question before the court was simply, was threefold. Firstly, was the statute passed for a religious purpose and therefore void? The Privy Council said there was no such doctrine, and in any event, it wasn't passed for religious purpose, but to produce a democratic compromise between areas of public opinion in Bermuda, which had been, this question had been very controversial. Secondly, was it in breach of the right to freedom of conscience of the people who wanted to see civil unions recognized as marriage? Answer, no, because they could continue to hold that belief and were not affected by the statute. And the third one was whether or not the belief in question was a creed, and the creed, the Privy Council said that a creed is a system of belief, not a single belief. And so it rejected that argument too. So the section stood. But the principle is the same one, be you ever so high, the law is above you. And the court cited a decision of Justice Kentridge from the South African Constitution Court, saying that if you must stick to the text of a statute, you must not go and ask about values, because if you apply values, the answer is not interpretation of the statute, but divination. So in my respectful judgment, the court was, the Privy Council, as it has done in every other case, was fulfilling its function as the final court for Bermuda.
So Lady Arden's reference to values as compared to interpretation might provide a good introduction to any closing comments anybody else on the panel wants to make about the relationship between law and society and social movements. Judge Rhee, yes.
It has been always difficult for law to keep up with the changes in society, and the sheer magnitude and speed of the change of our time is quite unprecedented. And then it is such a difficult issue for the court to deal with these issues with old laws. So, at least in the case of the United Nations Convention on the Law of Sea, there are kind of references to external rules, which is included. And also, there is an open-ended concept that the court or tribunal can utilize upon. So I believe that the task of the tribunal is not to create a new law or something like that, but to find the law which might be applicable through interpretation, taking into account the advance in science and technology, and also taking into account the relevant international instruments in other areas. That's the point that I would like to make.
Thank you very much. Justice Gutiérrez, yes, I'm giving you each a minute. We're over time, but I've got a minute for each of the last two speakers.
Well, I think the basic premise in a democratic society is that the Constitution applies to everybody. And in any society, there are going to be groups, discrete minorities, which are not represented in the democratic branches of government. And I think it's the court's role to ensure that the Constitution applies to them as it does to the minorities, and it ensures that those minorities that may not have a voice in the democratic branches of government are respected and their rights are upheld as per the Constitution.
Thank you very much. And Judge of Pangalangan, you get the last word.
Thank you very much. I'm sorry. On the relationship between adjudication and social change, I actually speak for judicial restraint, because I think today courts are under so much pressure to respond to political, the passions of the moment, and that a tendency to pander to the gallery. And I think that it is important for judges to be reminded that the rule of law means that they just, to follow the law and interpret the law, and that they strain the legitimacy of the courts by trying to be everything to everybody. And I go back to the definition of judicial power by Benjamin Cardozo, and his plea for patience with general principles. And I think the classic formula of Cardozo applies to this day. Thank you.
Thank you very much. I hope you'll all join me in thanking the panel for what I thought was a terribly interesting discussion.